Welcome back to another episode of Like That Law. Today we have Mr. Lim Wei Jiet, who is a very accomplished lawyer in his own right and has recently started his own law firm, Lim Wei Jiet & Co., a LexisNexis 40 under 40 lawyer. We're very privileged to have you. And as always, Professor Andrew Harding with his very sharp questions. Let's jump right into the questions that we have for our guest, Mr. Lim Wei Jiet, today. Let's start with an easy one. Why did you choose law as a career?
Well, if I were to trace back, it would be in my pre-university days where I was actually enrolled into the biological sciences path with the aim of becoming studying medicine or dentistry. And I think that there were two things that triggered a change. The first is the realization that I was kind of mediocre in biology and chemistry. I would score an A, but scoring an A in the Malaysian education system isn't really telling much of anything because you're just regurgitating stuff. So I thought that I would be an okay doctor. I won't fail as a doctor, but I will be an okay mediocre doctor. But in contrast, I love the languages, English literature, history, and I have to credit my mom for instilling the love for reading in me since a very young age. So at that point in time, I realized that, look, I'm quite good in languages and I love sociology, history and all that. I think that I would be a better lawyer than a doctor. I don't think I'll be a great lawyer, but certainly in comparison, I'll be a little bit better doctor than a little bit better lawyer than a doctor. So that is a very naive view of things back then. So that's the first trigger. The second trigger was really because at that point in time, there were independent news portals like Malaysia Kini, like Malaysian Insider, which were providing very interesting analysis of the kind of human rights issues and violations that were happening at the time. And that was the time of the Najib Razak government. And you see, Bersih protests getting quashed, activists from the opposition getting jailed, media outlets, getting their license revoked. So it was quite tumultuous, and to me, I was kind of angry at the situation at that point in time. I felt very powerless, but I wanted to do something to change it. So, I reflected on myself and I told myself that, look, by becoming a doctor or a dentist, I can help other people, which is a good thing. But being a lawyer, I can help others too, but I can also, in the process, hold the government into account, and make them answerable for their violations, bring them to court. And that's the exciting thing that I wanted to do. So I thought that, well, all in all, being a lawyer sounds a little bit more interesting than being a doctor. So no disservice to my medical friends. I'm not trying to put them down, but that was the very naive process in my mind, what went through. So in summary, and I hope I answered the question, that was how I fell and stumbled into the law. And as I went to law school, obviously my love and passion for the law grew. I love the intellectual rigor. I love the stories, the cases that I was reading. I love how the law was influencing, what was happening globally, internationally, domestically, how it intersects with politics, how it intersects with crime, sociology, race relations. So it was a discipline that you could very directly see and feel on a day-to-day basis. It was very much alive to me. And that's where my passion in the law grew. And, of course, as I entered legal practice, I also love legal practice and I am where I am here today because of I still continue to love the law and I hope I answered your question, Benjamin.
Yeah, absolutely. I think no one.
Inspiring answer. Thank you.
Yeah, it's a very
That was wonderful.
exhaustive answer.
We were slightly amused on this side because last night Benjamin was saying how he was supposed to become a doctor, but somehow he's finished up as a lawyer. So it might be true of quite a lot of people, I think.
Right. In fact, I do some medical negligence cases as a lawyer. So it's one of those areas where you can put both your lawyer and your doctor hat on also. So that's something I do enjoy, yeah.
Yeah, medical negligence
Great.
is like one of the areas of law that I think half of our class is interested in. And I think that's definitely no less contributed by the amount of science students going into law.
Yes. Can I ask you a sort of subsidiary question here to put it in a rather legalistic way? I'm just wondering, I mean, a lot of studies show that people who become lawyers because there's some important person like a mentor or a senior relative or somebody in their lives who sort of points the way. Is that true of you, or it's completely spontaneous in your own head?
Well, it's not really true for me. The only distant relative I have, I did not have any close relatives who were lawyers. The only distant relative I had was my grand aunt, who was a partner in Sean Delamore, but she is doing conveyancing and all. So, and I didn't really interact with her throughout my early years. So so it was really shaped through, reading blogs, which was a thing back in the day, reading independent media like Malaysia Kini, reading about my childhood heroes like Kapil Singh, for example, to see how he stood up for what is just and fair regardless of the consequences towards him. So those are people that inspire you and inspired me certainly to go into the law. So I have to credit those heroes that I read in the news, like Ambiga Srinivasan, who eventually became my pupil master. Those are people who were really inspired me. So yeah, I mean, nothing closely related relatives wise, but certainly from what I read from the news. Yeah.
But those people were influential after you already made the decision to go into law. Is that right?
I would say I would say even before I decided to go into law, I was already enamored. I was already reading about their exploits in the courts and everything. But I felt that law was, something that was a secondary or third choice. I didn't really pay much attention. It was only in the middle of pre-U that I decided to switch.
Right.
That's actually very interesting. So we've heard how your journey started out with science and all the human rights cases that inspired you to go into the law field. What actually is your current practice area now? I know that you do human rights cases, but is that the limit of your practice, or do you do other field of law?
Right. I think my legal practice today can be divided into three main areas. The first is commercial and corporate litigation. This is really a catch-all discipline which includes things like minority oppression of shareholders, breach of directors' duties, breach of contract, anything to do with commerce and within the corporate structure if there are disputes arising. So that is something that I did since my first year of practice, and I love it until today. So that's one. The second area of practice is employment law. So yeah, I do represent both employers, employees, trade unions in employment disputes. And third, of course, is human rights and public interest litigation, which I continue to do even from the first day of my practice and until today. So yeah, those are very broadly are my areas of practice.
Yeah, I think when I heard corporate and commercial litigation, and all the disputes that came out, I got the shock of my life, like thinking, oh, my company law module actually has some sort of importance in my future practice. Hopefully I'll come to love it. But how do you find actually in terms of your area in company law? Do you find it actually as dry as some people make it out to be? Or what's like the most interesting story you have for us in company law, without breaching confidence, of course, of your clients?
Good question.
Right. I mean, company and corporate and commercial litigation is, I wouldn't say it's a dry subject, because perhaps I'm working on the disputes part. I suppose that if you draft shareholder agreements or you draft company constitutions, that's a different practice altogether. That's corporate law. So I wouldn't comment on that. I was not exposed to it. But what I do is, I suppose when shit hits the fan, then the matter comes to me, and that's where it becomes interesting, when directors fight among each other, or whenever a shareholder from a minority shareholder is being oppressed by the majority shareholder. So I just to give an example, I wouldn't say it's a very interesting case, but you have a case whereby you have a Malaysian engineering company which collaborated with a Scandinavian oil and gas company to establish an engineering consultancy in Malaysia. And my client was one of the shareholders or one of the directors. And this relationship, lasted for 15, 20 years, and then one fine day, that Scandinavian company decided that, look, I'm going to establish another Malaysian subsidiary, and I'm going to channel a majority of the engineering work to that subsidiary. And that subsidiary is 100% owned by the Scandinavian company. And my client was essentially ousted, and all the business was channeled to the other company. So obviously, this is a case where the minority shareholders are being oppressed or being taken advantage of, and that's where we go to court, where we went to arbitration in that case. And so, fortunately, we won at the end of the day. And so those are just a snippet of what goes on when I say I act for clients in corporate and commercial litigation. Those are the kind of disputes that I do, and I just need to point out that if you look at the what we call the very respectable and well-known public interest and human rights lawyers in Malaysia, to name a few, Ambika Srinivasan, Malek Imtiaz, Cyrus Das, Gudial Singh Nija, they actually do a whole lot of corporate and commercial litigation also. And I do believe that their expertise and their experience in corporate commercial litigation, civil litigation, whatever it is, makes them a better human rights lawyer. It complements their role in human rights. So very rarely you will see in Malaysia where an advocate only does human rights law and nothing else. Perhaps it is because you need to find an area of practice that still brings in the bacon, so to speak, or brings in the bread, and that's where corporate and commercial litigation comes into the picture. But I think that Malaysia as a whole, we are not mature or developed enough as compared to the UK or the US, for example, where I know, like for large law firms, for Magic Circle law firms there, they have in fact dedicated public interest or human rights departments where their partners and lawyers almost only do exclusively human rights work. And they can survive financially by doing that. But I am afraid we have not reached that level of maturity or development yet in Malaysia. But that's my take on it.
That's really interesting. I mean, that you just confirmed. I was going to ask you this very question actually, and you've already confirmed the answer in detail. And I mean, if I understand this correctly, this also operates at the level of the individual law firm. So you've got pretty large firms that you describe as ordinary commercial practice, but they have this sort of public interest stream or section of people. So just as you described it, yourself, the individual lawyer, having this range of things, that applies, doesn't it, at the level of the firm itself? And if I'm right, also there's an element here of the commercial side, so subsidizing the public interest side. I mean, I remember, for example, those few cases like the Adong case about, in indigenous land rights, the Orang Asli land rights and so on. I mean, all of that litigation, I think, was done pro bono. And I remember sort of asking, I think it was actually, I think it was Cyrus Das actually, how do you all manage to? Because there are a lot of lawyers involved. How do you all manage to do this? Well, basically that was the answer, that it's all being subsidized by the corporate work. I'm not sure that this is evidence of not being sufficiently developed in this area. This seems like a pretty good model to me. I mean, it's not like, you're talking about the UK and the US. I mean, in the UK, we have things like, what is it? The Good Law Project. And there are some chambers, I think one Essex court, for example, specialize in this area. But I don't see the Malaysian model is inferior in that sense.
Right. I mean, just to be clear, I'm not saying for once that large law firms don't do pro bono or public interest work. Far from that. I think, Prof, you gave very good examples where recently there were a slew of orang asli cases where I believe the lawyers on board were from the larger law firms in Malaysia. So that's commendable. But I would say that as a general rule, again, generally, I suppose there are two kinds of public interest work. The first kind are the relatively uncontroversial, in the sense that you are not directly confronting the federal government or the state government of the day, in the sense that, like, orang asli cases, or fighting for a single mother against a criminal charge, or fighting against animal cruelty. I mean, those cases would generally gain support from across the political divide. But the second category of public interest cases, where, for example, you represent opposition politicians who are being charged for sedition, or you represent a media company whose license has been revoked, and that would invariably mean you have to go up against the Ministry of Home Affairs, for example, or the Prime Minister or the government of Malaysia. Some large law firms shy away from that, probably because of the very unique scenario in Malaysia, where the state is involved very much so in the business side of things. So you have a lot of GLCs, government-linked companies, and a lot of these large law firms have GLCs as their clients. And perhaps from a business perspective, they will not want to touch on the toes or offend these clients because they took up certain cases which are, very directly go up against the government of the day, So they do take up cases, but I believe they are a little bit more selective in that regard. So I do really, commend, and I hope that the large law firms do continue to take on pro bono and public interest work, because that work cannot fall solely on the small and medium-sized law firms who are under-resourced, or not as resourced as the larger law firms, definitely. So I really, really love the larger law firms to have a larger role in public interest and pro bono work in Malaysia. They already do that, but we just need to take up to the next level.
So I think, as you said, corporate and commercial litigation does take up like most of what law firms do, even for small and medium-sized firms. I think my personal question would be to ask, do you think the company law or corporate law scene in Malaysia is actually mature enough to handle, for example, oppression against minority shareholders? And do you as a litigator find actually wanting areas of law in Malaysia when compared to other countries that are maybe more advanced in their company law, corporate law, such as maybe the US or the UK?
I think corporate and commercial litigation in Malaysia is relatively quite advanced. I mean, we have had oppression cases since the 60s and 70s. And whilst our statutory framework, such as our Companies Act or the winding up provisions, may not be as up to date as Singapore or the UK or Australia, for example, I believe that our body of case law is certainly on par. And certainly our members of the bar who are well-versed in corporate and commercial litigation, they stand shoulder to shoulder with the best from Singapore, Australia, and the UK. When it comes to international arbitration, for example, where you get to spar with your foreign counterparts. So I wouldn't, Malaysia is quite good in that regard,
Yeah. So interesting. And I would like to note that Mr. Lim Wei Jiet is a litigation lawyer, which is a very rare thing for a partner. like of a law firm. So you exclusively do litigation and not really conveyancing side of things. Like that is like the bread and butter of most law firms. Can you tell us, because of your very specific area of focus, well, not really that specific. I mean, in the UK, barrister is a profession in and of itself and separated from solicitor. But can you tell us what are the traits of a good litigator, in your opinion?
Yeah, I think before I answer that question, I just need to clarify that I think that there are even more conveyancing or corporate lawyers in Malaysia than litigators. In fact, so it's not an unusual thing. But okay, just to directly answer your question, what are the skills to be a good litigator, I suppose is the meat of your question. I think firstly, the ability to very strategically and thoughtfully frame your case. And what I mean by this is that given the same facts, there are 101 ways to present that same facts in court, depending on the lawyer. You may want to prioritize certain facts, or you may want to open your case by focusing on the law. That depends on your strategy that you have in mind, and that depends on how you frame the case. And you want to frame the case in the most logically persuasive manner possible, one that will make the judge and jury say, of course, I have to believe what you're saying. It just follows. You have to also pitch your case in a manner that is most emotionally engaging to the judge, one that is able to capture his or her sympathies that they will side with you eventually. So that's what I mean by framing a matter at the end of the day. And that takes a lot of experience in court to do that. So that's number one, how best you frame your case, because the best litigators do it so well. They're able to convince the bench within the first 2 to 3 minutes just by framing how the matter should be looked at. The second quality I would say is the ability to be concise in your arguments. In this day and age, because of the speed at which cases are being heard, sometimes you have 7 to 8 appeals in a single day. You really need to capture the attention of the judges in the first 5 minutes. So you have to be concise, And nowadays, I often open my case by saying, look, my lords and my ladies, there are 3 grounds of appeal. The first is A, B, C, D, and that's you go straight to the meat and heart of it. But you also need to be able to package it in a very concise manner. No one is willing to wait for the meat of your argument to only arise at the 20th minute. They don't have the patience anymore. You need to be very concise, but you cannot be simplistic in your arguments. And there's a difference between being simple in the delivery and being simplistic in nature in your delivery. And the third quality is to be able to be flexible and pivot well in the middle of your argument. So what I mean is that you need to think on your feet. Sometimes in Malaysia, for example, if you go to the Court of Appeal or the Federal Court, you will only know the composition of the judges on the morning itself. So you need to, upon knowing who the judges are going to appear, you may need to change course because, for example, the chair of the Court of Appeal panel may have already written a grounds of judgment 2 months ago on a point of law that you may want to submit. And his or her position may be different from your point of law which you want to argue. So you may want to, not put that legal argument as your first point, for example, but put it as your second or third point, because you don't want to lose the attention of the bench when you present an argument that is not compelling already in the eyes of the chair of the panel. So that is an example of how you need to pivot. And for example, and I can give you another example. For example, if you are the respondent side and you only stand up after your appellant has submitted, the appellant lawyer has submitted, throughout the appellant lawyer's submission, there may be questions which he or she may not be able to answer, which is very pressing in the mind of the judges. And as the respondent, you ought to address that particular question head on as the first few lines of your submission to assuage the mind of the judges, so that they are clear and they are with you, You are seen as a credible advocate who knows the answers that they are begging an answer for. So that's what I mean by being flexible, at the end of the day. So those are really the heart and core skills of a litigator. But if I may venture more into qualities which make you good in anything that you do, not necessarily litigation. And this is something that I would like to quote Roger Federer on. And the tennis legend used to say this, and I think it encapsulates it very well. And I quote, talent has a broad definition. Most of the time, it's not about having a gift. It's about having grit. In tennis, like in life, discipline is also a talent, and so is patience. Trusting yourself is a talent. Embracing the process, loving the process is a talent. Managing your life, managing yourself, these can be talents too. Some people are born with them. Everybody has to work at them. Unquote. So I believe that what Roger Federer was saying is that, not only do you need to be good in the technical skill of tennis, but you also need to have grit. You also need to have discipline. You need to have patience. You need to have trust yourself and to love the process. And all these qualities are important in not only becoming a good litigator, but becoming good in anything in life. And one particular aspect I wish to emphasize is grit. In litigation, you need to have grit because you are likely to experience losses a lot of times in litigation, more so in public interest and human rights cases where 8 out of 9 times, I would say, you lose in court. But you need to stand up and dust yourself and move on and soldier on. If you don't, I am afraid all the other qualities that I've mentioned before, being strategic and knowing how to pitch your case, it doesn't matter if you can't pick yourself up after a loss.
Mm-hmm. I think that's absolutely fantastic advice. And, we're kind of hoping that there's a lot of young law students and young lawyers watching this. And I don't think they could have a better summary of the qualities that they should be thinking about developing. And this business of being flexible when you're on your feet, it sort of reminds me of what Mike Tyson, the boxer, said about, everybody has a theory until they get punched in the mouth. And, I'm sure that sometimes happens when you're framing your submissions in court, right?
Right. That's a beautiful phrase by Mike Tyson, definitely. You can be as prepared as possible, but once you get punched in the face by a question from the judge, which you have never expected on, then you just completely lose track and you really have to just provide an answer on the spot. And it does throw you off guard, but through experience, through enough preparation, you should be able to pull through from it. But yeah, beautiful words by Mike Tyson, that one.
I think Mr. Wei Jiet's answer showcased that he indeed has the good traits of what it means to be a litigator, answer being so concise and emotionally powerful and cogent. Yeah. I think that's very good. I think it would help the students understand what sort of qualities they need to have. But what sort of advice do you have for students in terms of cultivating that sort of ability in court, in standing up and being able to stand and think on their feet, in being able to be concise in their arguments?
Yeah, I mean, if I were to speak to a 18, 19-year-old law student, for example, and if they ask me, what should they do today if they aspire to be a good litigator in court in 5-10 years' time, I would say, number one, to the best that you can, try to involve yourself in activities like mooting or debating, where you really are pushed into a situation where you have to stand up on your own 2 feet, where you have to face a barrage of uncomfortable questions, where I think that mooting and debating does really push you out of your comfort zone, and you need to get out of your comfort zone in law school. You need to be able to be placed in a situation where you get punched down, you lose, you stand up and you soldier on, you fight another day. And those are things which I would advise if you want to go into litigation. If you want to be a corporate or conveyancing lawyer, you may want to explore different things. But a litigator, that's certainly number one. Number two, I would say try to be as well read as possible. And what I mean by this is, pay attention to what is going on in the news, what's going on around the world, like the Trump tariffs, what's going on geopolitically in Ukraine and Russia, what's going on domestically, what's going on, in Pakatan Harapan, what are the laws that are being passed, because you really need to be able. I think what the qualities of a good litigator is that you're able to hold a conversation, a matured conversation with another person, and that you need to carry yourself well. And one of the ways to carry yourself well, to have the confidence to speak, is to be well read. You know about things that are happening around the globe, and you are able to offer an opinion and input in any conversation out there, not just in court, but as you mix with senior lawyers or barristers who may be 10, 20 years more senior than you. If you have the ability to hold a conversation with them in a matured way and offer an opinion or input, that goes a long way, that they will treat you that you are as a matured person who deserves respect, and they will pay attention to you. If what you come through as is just having a very shallow analysis of in football, for example, no disrespect to football, but or if you can't offer anything more than what university students speak about, then you don't stand out in life. And so being well read is something that is what I mean. And it can be as simple as if you're on Twitter or Facebook, just follow Time, The Economist, The Guardian out there. Just keep yourself abreast of what's going on. You don't necessarily have to read 10 articles a day. I'm not asking you to do that, but as you just amalgamate it in your social media lifestyle, it can be as simple as that. So yeah, those are things that I would encourage law students to do, right? And try to write as much as you can. And I believe that in an era of ChatGPT, having the ability to write in a clear manner, be it through emails or your cover letters or your opinions or your written submissions later on, really does go a long way. I think that the art of writing well and good is kind of the dying art in Malaysia, I'm afraid. And if you're able to write it well, again, you stand out in Malaysia, I feel.
That's again, wonderful advice to students. I mean, as somebody who does a lot of teaching of students, I think, it would be great if they could develop that perspective, because there's a tendency to think that they must not fail at anything. They must never be embarrassed. They must never make a mistake. But as you know, and we all know, it's by making mistakes that you actually learn things. So we need to try, I don't know how to do this. We need to persuade them that sometimes you have to just jump in at the deep end of the swimming pool and see how you can swim. And you may fail, but you'll fail better each time until you finally succeed. But that doesn't seem to be their perspective. So I'm wondering, how do we kind of achieve that situation?
But perhaps I can give a story. I remember back in law school where there are some of my batchmates who may not speak English that well, may not have the communication skills to convey what they are saying as well, who may not be able to write an essay very well, but they have the courage and tenacity to volunteer themselves to enter into mooting competitions, to join club activities, and they will fail. They get knocked out at the first few rounds, but they don't give up, and they persevere, and they do it again and again. And today, these same people who I thought would not likely become litigators, they may venture to do something else, they become good litigators because they they had their shot of failure very early on. They were not afraid to fail, and they did not give up. So they went to, after they graduate, they went to certain law firms. They were thrown in the deep end, as you said, Prof, in litigation. They were probably mocked by their pupil masters for not having a good command of English, for example. But that did not deter them. And they are today better litigators than the ones whom I thought would be good litigators. You know, the who may speak with an accent, who may have a good upbringing in terms of their proficiency in English, but because they thought they were very good, they did not really try to go out of their comfort zone, and they did not have their fair share of failures. You know, a lot of them don't end up being litigators. They do something else, and even if they do become litigators, they don't do as well as those who try and fail at the beginning. So, you know, to your students, you know, perhaps you could gain the lesson in that. That is what truly and really happened in from my very short time at the bar. This is my perspective that I've developed. So don't be afraid to fail.
But I think as a student, Mr. Lim Wei Jiet is definitely excellent, having been awarded the Tun Sifian Scholarship when he was at I would just like to ask a question on your opinion between the difference of actually the academic arguments of the different constitutional topics and issues out there, which is in relation to the human rights cases that you do quite frequently. Do you find anything that stand out in your practice that's not specifically highlighted in the Malaysian academia when they're talking about constitutional issues, but it's one of the most salient topics when you are presenting in court? Does anything come to mind?
I'm not sorry, if you can frame that question again. I didn't really get your question.
No worries. Sorry, I think I framed that quite confusingly. I think my question is basically, do you find any sort of issues that are highlighted in court when you're presenting about a constitutional topic, but it's actually very lacking in materials when you're looking into journal articles in terms of the academic realm out there when they're writing papers, that they're not aware that this issue is actually very salient and very relevant to constitutional litigators?
Right. I suppose one area which perhaps Malaysian academics don't touch as much is really, I mean, the trend I'm seeing now in the federal court and Court of Appeal, for example, is that they are willing to look at fundamental rights in a very prismatic manner, and are willing to expand it beyond the cold letter of the law, so to speak. And I think a lot of judges are willing to explore, you know, what does right to life mean? It means more than just animal physical existence, but right to a clean environment, you know, etc. And I would really love, you know, academics to explore, to just push the boundaries of your imagination on what these rights may be. You know, what can right to life be expanded to be, and that can inform our arguments in court. Because more often than not, judges do pay attention to what professors write insofar as constitutional law is concerned, and they do try to, as much as possible, be in line or be in consonant with what the academics are exploring. And so yeah, if the academia could really touch on that, that would really benefit, and that could really complement our arguments in court. I'm not sure whether I answered your question, Benjamin.
I think that perfectly answers.
I think that makes a lot of sense to me. One thing that I've heard sometimes from practitioners about this is that they wish that the academics would do more work on, what should we call it, the theory of interpretation. I mean, what is happening when the judge interprets the Constitution, for example? I mean, what are the premises? How should they approach it? For example, famously, do they look at the Constitution within its own four walls, or do they look outside to see what is happening in other countries? And would lawyers be able to cite cases from, say, South Africa or or Australia or the United States or wherever. That's sort of one perspective. And should they see the Constitution as something that's kind of set in stone, or is it more of a kind of living tree that can develop as society develops? And I think that is a criticism that people make, and I think that's a fair criticism. I think we should address those issues at a sort of higher level of abstraction and see what we can make of it.
Yep, absolutely. And I think that whenever, because Professor Andrew Harding is in the podcast, I would mention that it is very instructive and useful if credible academics like Professor Andrew Harding or Prof. Shad Salim Faruqi, whenever they write an opinion or an article on where the law how the law ought to be interpreted or where the law should be, and when lawyers cite those cases, cite those authorities before the Court of Appeal and the Federal Court, it does hold much persuasive weight in court. So I will always, whenever there's a live controversy or issue, I always nudge Prof. Shad Salim Faruqi to, why don't you include this in your opinion article in the Star, why don't you write on this? Because it does push the envelope, so to speak, and judges do pay attention to what academics write. So I would really encourage the academics out there to write more, because the one of the weakness, if I may, Prof, to highlight among the Malaysian academics is that I believe that if you look at the textbooks that are written by most Malaysian academics, generally they just analyze what the statute says, and they don't go further than that. They don't open your mind to the different possibilities, or they don't go one level deeper on what Australia or India or the UK is touching upon this subject. It's always very surface level, when I read about patent law, for example, or the Malaysian academics will be very surface level on the analysis of the textbook. And sometimes when I buy this textbook, I will tell myself that, look, I can read the statute for myself. I don't need your surface level analysis. I'm buying this textbook because I expect it to be an equivalent to, a Bullen and Leak in the UK, or for example, where there's a very rich analysis that is going on by the author, but that seems to be missing in Malaysia for some reason, and that is a criticism that I have, if I may, just to put it out there, since we're on this topic.
I think again that is a very fair criticism. We're taking a few things on the chest on this side, but I think that's quite right. I mean, as I see it, as an academic, it's our job to deal with the ideas behind the law, to sort of formulate, refine, relate ideas to each other, and explore what is possible. And I actually agree wholeheartedly with what you say, because I mean that job of providing purely what they call black letter legal analysis is actually very well done by the legal profession itself. I don't see why academics should try to do better that which people like, I mean, you yourself with great contributions to Halsbury and Sri Murugan and other people have written really excellent books that we can use as legal practitioners. Our job is to go beyond that and deeper. I totally agree with that.
Yeah. Okay. So now, moving beyond, I think, the surface level analysis of the law, I think you hinted at the reading of the Constitution in a prismatic approach when we are approaching fundamental liberties. I recently had the privilege of observing you submit before the federal court in the case of Amir Hariri against public prosecutor. And a very interesting argument in contention, actually, from the submission point of view, is the idea that the Constitution can be read in one of two ways. Either as a historical document where we, wholeheartedly abide by the cold letters of the law and, cling to whatever the founding fathers want, or treat it as a living document where it grows its branches and adapt towards the modern world. This issue is actually very salient, I think, in the United States, in some other countries with written constitutions that are quite old, I would say. But in Malaysia, I think this is the first case where I see a lot of expounding upon this idea of whether we should apply the constitution in a historical manner, which is the originalism format of things, or should we actually go out and say that, the constitution in itself have to actually adapt to the modern world, and that the judges have a duty to read the constitution in such a way that it's relevant to modern society. What's your opinion on that?
I think it's quite established in Malaysia that the constitution should be read prismatically, liberally. I think that has been established since 2010 onwards, and it has been continuously emphasized until today. And that is certainly the position of the latest federal court cases. We have to read it in a prismatic fashion. But of course, the government and certain parties would want to advocate a position that, you should only look at the letter of the law. If you want to deviate from that or read more than what the letter of the law says, it's for Parliament to legislate and to amend, and it's not for the judges to interfere. So that is the common argument. But I think that insofar as Malaysia and India is concerned, and we borrow a lot of Indian jurisprudence insofar as constitutional law is concerned, it's pretty well settled that we should read it prismatically. Of course, in countries like in the US, the debate still rages on, originalism versus liberalism, and I believe that the US Supreme Court today is dominated 6-3 by the conservative faction, so they are kind of leading towards the originalism path. So it's very interesting to see what's going on in the US. So I had the privilege to do an exchange program there for half a year in my undergrad years, and so I was very much exposed to this whole debate, and then Justice Scalia and what his opinions were. So it's very interesting topic to me, and but insofar as Malaysia is concerned, I think it's pretty well settled. We should look at it prismatically, but sometimes judges may not want. But then it's become subjective as to how far you want to stretch the letter of the law. Some people might say that right to life in Article 5, for example, shouldn't extend to right to a clean environment, or the right to have, for example, internet access. Should it extend to that everyone should have the right to have free or affordable internet access when it's so specific in nature? Could you really say that life includes that? So judges, so that's where judges then swing back and forth as to how far you want to push. So even though we accept that we should look at it prismatically, how far can we push? And that remains up to debate.
Yeah, absolutely. That's a great perspective. The danger of this kind of reasoning is that perhaps there are occasions where the decision looks quite arbitrary, because you've got this sort of sliding scale, as you indicate, saying that it's a prismatic or evolving interpretation doesn't answer in itself every question. You've got this sliding scale, and where on that scale the judge wants to put himself or herself, may look quite arbitrary. And of course, you may have differences between judges and courts as to how far they think they ought to go. But as you pointed out, the federal court seems to be quite consistent the last sort of 10 or 15 years in terms of how they've approached these matters, and hopefully that would continue to be the norm. But what do you think about this? Can we expect that it will continue to be the norm? What I have in mind is that it's all very well to say the Constitution is a living tree, but what if somebody comes up with an argument saying that, for example, Islam is the religion of the federation, and therefore all the other provisions of the constitution should be interpreted in an Islamic context. That's what they might mean by a living tree. How would one react to that? What do you think?
Yeah, I mean that's where I suppose the quote unquote the danger of the prismatic living document argument may turn up. I don't foresee that someone will argue that because Article 3 prescribes that Islam is the religion of the Federation, therefore all other laws should come in conformity with it, will happen in the next 15, 20 years. I don't foresee that happening. But what I do foresee is, and this is a very realistic perspective, our trend of progressive jurisprudence and constitutional interpretation happened because we had the right judges at the top echelons of the judiciary. People like Richard Melanjung, Tun Tengku Maimun. I'm raising this topic because Tun Tengku Maimun's retirement is coming soon. You know, she's retired around June or July. And therefore, it is imperative for the government of the day under Anwar Ibrahim to appoint the right judge to become the CJ and the chief judge of Malaysia, the president of the Court of Appeal, because they play a pivotal role in how the judges interpret the Constitution. Whatever signal they give through their judgment or through their speeches reverberates to the Court of Appeal, the High Court judges. And we have had a good 5 to 6 year run previously because we had the right Chief Justice at the helm who has been giving out these good progressive signals. That can change overnight. That living tree can be cut off by an axe if you put the wrong person at the helm.
Yeah.
And I'm afraid that is the risk that may happen in Malaysia, because appointing the wrong person can change an institution in and of itself very drastically. Unfortunately, I don't think Malaysia has very strong institutions which can weather any individual who was appointed to the post yet. So we need good judges at the helm, especially, who will continue this trend of interpreting and giving progressive judgment. And that's what I hope to see happen. And that's a real fear in me that it may be derailed in the next 1 or 2 years,
Yeah, what you've kind of drawn attention to is something that's becoming very current in academia, which is interpretation of the Constitution outside the courts. In this instance, that kind of interpretation impacts directly on the courts because you're talking about the appointment of important judicial officials. So I think that's one area which, as academics, I think we are developing this area. But traditionally, people have focused much more on case law and constitutional interpretation in the court, and some of us are trying to take it outside the court and see what happens. Then, of course, it becomes a matter of, well, how do you actually sort of create these constitutional values among politicians and civil servants and so on? And I want to bring this down to a question which I'm kind of burning to ask you, because we've had great insight into your own career as a litigator and how you developed and how you see things and how you deal with litigation at the practical level. But you're somebody who's also stood for election to Parliament. So what I want to ask you is, since the conversation is leading right into this area, how do you see the relationship between law and politics? I mean, not in an abstract way, but in your own kind of personal perspective, in your personal kind of career trajectory and so on. How do you see that?
I think that unfortunately in Malaysia for the past 30 or 40 years, law is used as a means to achieve political ends. Laws like SOSMA, like the Printing Presses and Publications Act, they were designed to ensure that the government of the day stays in power. And unfortunately, until today, that seems to be the culture and practice. I have to give credit to the Pakatan Harapan-led government. They did pass several progressive laws in recent years. It's not that they did not, but when insofar as the expectation of the citizens that they would go one step further to institute real legal reforms, such as revamping the appointment of judges, abolishing archaic laws like the Sedition Act and Section 233 of the Communications and Multimedia Act. Those things are not happening yet, and the dynamic between politics and law really boils down to the fact that these legal changes are not happening because the politicians of the day do not believe that they will gain political support of the rakyat if they do implement these changes, or political support among their coalition partners. So, for example, I do feel that certain factions in Pakatan Harapan really do wish to see these progressive laws being passed, but it may be opposed by their coalition partners. It may be exploited by the opposition politicians to label Pakatan Harapan as anti-monarchy or anti-Malay or anti-Islam, and therefore the changes that come with the law are slow or non-existent at the end of the day. So I suppose to answer your question, legal changes happen only if the socio-political context of the day allow for it. And that is also the reason why I felt very disappointed that when Pakatan Harapan in 2018 got a very overwhelming mandate, if you recall, almost 2/3, or if I stand corrected, that they did not implement legal changes fast enough. And because they had the wind was in their sails, and they could have passed certain laws and the rakyat will still be with them because the positive momentum was there, but they delayed. And I remembered, because I was not in politics then, but I was engaged by the ministers in certain task force to revamp the law, to, for example, introduce ombudsman legislation, and what we were given was PowerPoints which have very generic bullet points presented to us, and us from civil society were asking, give us the draft legislation, give us the draft law, because the devil is in the details. Why are you being so slow? And that was already like the 7th or 8th month after they had won the elections. Why are you moving at such a snail's pace? And true enough, 12 months later after the election, we all know, there was turbulence and the Sheraton move happened, and the legal reforms that we expected, that the people voted Pakatan Harapan for, did not materialize. And so that happened in 2018. So post 2022, unfortunately, Pakatan Harapan, but in and of itself, did not manage to gather a majority to form a government. They had to work with Barisan Nasional, and therefore the legal changes are non-existent or very slow. So there's a reflection of the political realities of the day, and that's how I see law and politics intersecting. You need to strike when the iron is hot, so to speak. Unfortunately, that was not done in Malaysia, and I don't know whether we can ever see a situation where, for example, the climate would accommodate a repeal of the Sedition Act anytime soon in the next 10 or 20 years. I hope to be proven wrong, but I don't foresee that happening anymore.
Yeah, and apart from being slow, there were a number of occasions, weren't there, where there were simply U-turns, where things were promised, 1 month, and then the next month it was, all bets were suddenly off. Some people who were, I think, in the thick of all this, that I've spoken to, attributed the situation at least in part, to a very resistant civil service who tended to sort of bog down the discussion in detail, almost deliberately trying to make it not go forward with any kind of speed. And that's probably something that you would find in most countries, yeah, which can be a good thing when ministers are over hasty, but can be a bad thing if they're actually trying to move forward quickly with reforms.
Right. But since you mentioned that, Prof. Andrew, I will just give you an example. So I know a certain minister who wanted to push a very progressive law. I mean, I'm not going to name names just to protect the confidentiality and everything. But he wanted to push a very progressive legislation. He got the support of, the majority of the political factions of the day. But when he what the members from the Attorney General's chambers were saying was that, we need 6 months to study this and to come up with a draft legislation. And so the minister was baffled. Well, like, what do you mean you need 6 months? Like, it's a very simple legislation which has 3 to 4 paragraphs. It's not rocket science. Why do you need 6 months? And so he escalated the matter directly to the Attorney General, who was not aware that his subordinates had given that 6-month timeline. So the Attorney General said, hold on a second, I will come back to you in 24 or 48 hours with a draft legislation. And true enough, he came back with that. And true enough, that bill was tabled in Parliament and it was passed. So can you imagine if the minister, for example, did not take the initiative to pursue this further? Can you imagine if the Attorney General himself did not put his foot down to say, I will champion this and I will bring this through the finish line? And we are left to the inertia of the civil service. What would have that bill would have died, and that progressive legislation would not have gone through. Yeah. So this is a real life example. And I'm not putting down the civil service for one moment. There are very good people in the civil service, but there are people entrenched there who do not want to see changes happening, and that has been quite fairly established. I don't want to paint a broad brush on everyone. I've known fantastic civil servants, but there are certain factions out there who would rather things remain the same.
And do you think we have a similar situation with the proposed freedom of information legislation? Because it sort of pops up from time to time, but it seems to be quite a long time since it was originally mentioned. And I haven't noticed that there's really been any progress on that. So is this part of the same phenomenon?
Well, I cannot say for sure, but I think that the law minister, Azalina, has mentioned the freedom of the idea of enacting the freedom of information law since at least 12 months ago, if I recall correctly, or later than that. Equally, she has also mentioned ideas like separating the role of the Attorney General with the public prosecutor, for example.
Yes.
So, and I have been involved in some of these roundtable discussions, which frankly have been going on for the past 12 months or so. So I
likewise. I've been involved as well.
You may
have the same experience.
So, and I've seen, members of Parliament in the select committee going to the UK, going to the Australia for trips to understand the legislation. But so much time has passed, and I frankly don't see much progress. But I may be wrong. I hope I'm wrong that actually something real is going to come true in the next 2 to 3 months. But again, it goes back to the point, Professor, that I do not know why these things take so long. At the end of the day, I don't think it's rocket science. I think that if you put an experienced team together, they would have come up with a draft bill, in 2 to 3 months. It doesn't take 6, 12, or 18 months to draft a bill to split the AG.
No, I mean, you can even just do it institutionally before you enshrine it in law. That's just a matter of administrative organization. I don't see a huge problem with that. But, time is moving on. Benjamin, I think there might be one or two other things you want to ask. Is that right?
I think I just have two more questions. I think I just want to mention that I think the Freedom of Information Act is one of my, one of the topics that I'm very interested and passionate about, because the Freedom of Information Act is one of those things that I believe is fundamental to a democratic society. You may not feel it at first, but as journalists get on this act, as civil servants understand the need to disclose information and make sure that what they're doing is, proper and not going to be subjected to a FOIA request and subsequently being sued for negligence or something in court, I think it will definitely improve not only the quality of civil service, but also improve the quality of understanding the Malaysian government in Malaysia. So I think I just wanna maybe let's just end our conversation by asking one last question on turning back to your legal practice. What is like the most memorable case you've had like throughout your 20 years, 10 something years career?
No, I'm certainly not 20 years. I'm 8 years in practice.
Wow. You certainly sound more experienced and definitely felt more experienced in court than your age is.
Yeah, okay, just when you mean a few memorable cases, okay, it may take some time because, lawyers, once they speak about their cases, they don't know when to shut up. So spare with me. I think the one case that still is etched in my mind is the case we did for the Selangor state government to challenge the Election Commission's proposed boundary changes to redraw our parliamentary and state constituencies. And we did that in 2016, 2017, if I recall. We represented the Selangor state government. It was a very novel challenge in the sense that I don't think the courts in Malaysia had previously ruled on whether malapportionment, whether gerrymandering is unconstitutional or unlawful and should be struck down in court. And so it was very exciting because we needed experts like Professor Wong Chin Huat to write a report to show how malapportionment, how gerrymandering was indeed carried out by the Election Commission of the day to benefit the ruling Barisan Nasional government at that point in time. And we eventually, the issue that the government then raised was that, look, at the end of the day, the Prime Minister tables these recommendations by the Election Commission to Parliament. Parliament holds the final say on what should be the boundaries or not. Courts do not have a say. So in other words, it's not justiciable. And so we had to wrestle with that argument. Unfortunately, we did not succeed at the High Court and the Court of Appeal and eventually at the Federal Court. But it was the whole process of working together with the experts, working together with Ambiga Srinivasan, my pupil master then, working with Dato' Cyrus Das, who was one of the counsels then, and then working together with the Selangor Menteri Besar then and all. It was very exciting process for a first, second year lawyer. But it's also very memorable because what happened was that we managed to get an injunction or a stay of the entire electoral delineation process in November or December 2016. And that prevented the Najib Razak from actually dissolving parliament until like 1 year later. So obviously that was not our design and purpose, but that was the consequence of the legal suit. And what happened throughout that 1 year was that Bersatu managed to formally enter into Pakatan Harapan. They finally managed to close the gap or whatever differences they had. They finally managed to present a united front between Mahathir and Anwar. And the rest is history, as you know, in 2018. So I'm not blowing my own trumpet or anything. I certainly am not saying that I contributed to it. But is very interesting and memorable to me because on hindsight, it's so interesting to see how the stars align, filing a court case, getting the injunction, allowing the opposition parties to coalesce and to solidify, and then 2018 happened. So that was very a memorable case, which I thought it had a real impact on certainly my life and the trajectory of Malaysia. So that is one case that I will remember to my deathbed. The second case, if I may, is the Undi 18 case. So what happened was that Parliament passed a law to lower the voting age from 21 to 18 and to also allow for automatic voter registration. That would allow like millions of new voters into our electoral roll. But what happened was the Sheraton move happened and Muhyiddin came into power as Prime Minister, and for some calculated political reason, he did not want to gazette to bring into effect the constitutional amendment that had already been passed by Parliament.
Right.
So we represented Undi 18, the NGO which first mooted this idea of Undi 18, to go to court. In fact, the applicants in court, the litigants in court, were actually 18, 19, 20-year-old students who would be deprived the right to vote if the Muhyiddin government did not gazette the law to come to effect. And these are brave individuals who are willing to put their names on the line, who are willing to risk losing their scholarships, for example, because you're going against the government of the day. But they were very brave, and I was very privileged to work with them. And true enough, the Kuching High Court, obviously I'm not allowed to appear in the Kuching High Courts because I'm an advocate and solicitor of the High Court of Malaya, but we work with Sarawakian lawyers, and we managed to get an order from the High Court to say that, the Prime Minister has a duty to gazette, to bring into effect a constitutional amendment or a law that has been passed in Parliament. And that, in my mind, is the first time this has happened across the Commonwealth. I mean, certainly from my research, there's no previous precedent where the courts are willing to say, hey, Prime Minister or Executive, you have to bring into effect a law that's been passed by Parliament. So it was very memorable. And because of that, millions of young voters were able to vote in the 2020 general election. So again, those are cases which are memorable to me because they had a real social political impact on Malaysia. So those are just two cases that I can think of on top of my head. But it's not to say that the other corporate and commercial and employment cases are not as interesting. I can certainly go on and on, but those are the two cases that are quite memorable. Yeah.
Great.
But yeah, I think that wonderfully sums up our conversation with Mr. Lim Wei Jiet, who is an accomplished lawyer in his own right. 8 years of experience, wonderful litigation in all sorts of areas. The ones we've talked about today, mainly on constitutional litigation, definitely having a big impact, I think, on me for my right to vote as a Sarawakian. I think it was very exciting for me to see that a profession that was going into actually making, political, not just progress in terms of how the law should be just and fair for all, but also in terms of the structure and governance of it all must be in line with the law, which makes it, a profession that is versatile and universal in application. And I think we are just so privileged to have Mr. Lim Wei Jiet here with us today for the podcast. And thank you, Professor Andrew Harding, as always, with your wonderful expert input in Malaysian constitutional law issues. Hopefully your heart is not too hurt by Mr. Lim Wei Jiet saying that the academics need to improve on themselves.
No, we can always improve.
It's certainly not targeted at Professor Andrew Harding by no stretch. I would like to thank Professor Andrew Harding beforehand because, he has been a source of inspiration to me, reading his works on the Constitution, on how the Constitution ought to be interpreted, and it is really, he has really advanced, the state of constitutional law in Malaysia in many ways. And thank you also, Benjamin, for your initiative, for inviting me in this podcast. And I was really happy that you managed to follow and to follow us to the federal court to witness proceedings. Because I would always like, prospective lawyers and law students to come to court and see for yourself how a case is litigated. You can never get an equivalent experience like that in any other format. So I hope you learn.
I absolutely agree. It was a wonderful journey looking at Mr. Lim Wei Jiet expert submission in court. And I think in terms of Professor Andrew Harding's expertise, let's give you some airtime for your newest book, Territorial Governance in Southeast Asia. Would you like to say something about it before we end?
Well, thanks very much. I wasn't expecting that opportunity. But first, I mean, it's been an enormous pleasure and privilege that you joined us and shared all your thoughts, Wei Jiet. And I think we should almost make this episode compulsory viewing for law students, because I think it's really inspiring. And if they don't get inspired by this conversation, it's hard to imagine, what would inspire them. The book is called Territorial Governance in Southeast Asia, covers 5 countries. Malaysia is obviously one of them. And the book is being launched on Wednesday, the 7th of May, in the coming week, at the KL Selangor Chinese Assembly Hall, hosted by Project Sama. So I hope to see you and others there, and we can have a good discussion about the subject of territorial governance.
We will definitely include that in the show notes. And with that, I would like to end the show. Thank you so much once again, Mr. Lim Wei Jiet. Thank you, Professor Andrew Harding.
Thank you.
Thank you.